Another day to discuss something that is from famous people, celebrity court news. And today it is the popular audio that is going around, which is unconfirmed. In this audio, it is alleged that Minister Doreen Mwamba and Mr. Chabinga are having a discussion how they should influence South African court judges in this matter regarding the repatriation of the remains of our former president, Dr. Edgar Chagwa Lungu. Like I said, it is unconfirmed. The reason why we're having this discussion is because there's another social media page that said that audio has made it into South African courts. And I thought, why not talk about evidence and two principles, particularly admissibility and relevance. But first, definitions. What is evidence? So evidence is something legally submitted to court to ascertain the truth of something. If you watched The Law-Abiding Citizen, interesting line there was, it is not what you know that matters, but what you can prove in court. Now, evidence comes in different forms. You have documentary, you have oral, you have electronic, and you also have real evidence. Just like any public institution, even the courts of law have the obligation to use state resources effectively and efficiently, whether it's human resource, financial resource, or a time resource. Therefore, what is relevant is usually the preserve of the court to decide. They're the ones who decide whether something is relevant or not. And it is a fact or evidence is relevant if it contributes to the resolution of a fact in issue, or it is relevant to a fact relevant to the issue. So if the court decides that a fact or a piece of evidence or whatever is not useful to help them determine the facts in issue or an issue relevant to the facts in issue, it will not be admissible. Basically said, if it's not relevant, then it's not admissible. Admissibility. As a general rule, anything can be used in the courts as evidence as long as it is subject of the court's inquiry. That's a general rule. Anything can be used. But there are principles that limit the use of certain things to be brought into the court room as evidence, and I will give you examples of this. For example, there's constitutional provisions that make certain things inadmissible. For instance, in a criminal matter, the accused cannot be compelled to give a statement. Then you also have other statutes like the Criminal Procedure Code, which provides that as a general rule, a spouse is not considered a competent witness in the accused case. There are various other laws like the one for authentication, even our famous popular Cybersecurity Act. It has certain interesting provisions about what can and cannot be admitted into the court as evidence. Then there are also exclusionary rules under common law and the principles of equity. Like one would be privilege, state privilege. Did you ever watch either in Suits, or I think Olivia Pope is the one who did it under Scandal, where when they asked her to produce something and then she would say something like, that is privileged, so there is state privilege, certain things that in the interest of public security cannot be shared. And then there's also privilege like client-lawyer relations, where certain things will not be produced in court that were exchanged between a client and their lawyer. Then there's also the rule of similar facts evidence, and then there's also the rule against hearsay. Now, if I start talking about hearsay here, it will be a whole subject on its own, and I think I might make a video, because I'm telling you, it fumbles people. It used to fumble people both in law school and even at Ziale, what hearsay is. So we will discuss that in a separate video. I'm not promising. Maybe let's see if we will have celebrity news that will prompt us to talk about hearsay. So for me, what is interesting coming out of this situation is to hear what application was made in relation to the Edgar Changwa Lungu case regarding, first of all, let's even see if this audio has even made the courts in South Africa. Two, I'm curious to see if it actually has. What application was made? Is it evidence that will help the court resolve the facts in issue, which is the contention or the issue at hand in the case, or is it something that is relevant to the facts in issue? That's all I had for you today. I hope this was helpful. Until the next one, bye.